Hello everyone. So we were discussing part 6 of Indian Constitution, and as part 6 of Indian Constitution we already have delivered two chapters, that is chapter on governor and chapter on chief minister. The third chapter we had dwelled into, that was state legislature. Two videos on the state legislature has also been delivered, so this is going to be the third video on the state legislature. In the first video we had detailed discussion on legislative assembly, legislative council and other aspects of the state legislature. So let us see what is going to be the scope of this particular video. So see, in this video we will discuss the leftover topics, because almost every topic that we were to discuss with respect to the state legislature we already have discussed. So there are few leftover topics that we will discuss in this video, and there are certain declaration that has to be made. So there are two topics that we are not going to touch even marginally, and those two topics are, the first topic is privileges and immunity, because if you remember when we were discussing the parliamentary chapter, we already had discussed this article 105, and in article 105 that deals with privileges and immunity of member of parliament, that is member of Lok Sabha and member of Rajya Sabha, and privileges and immunities. See, privileges and immunities are enjoyed by member of parliament and house as well. So privileges of and immunities are enjoyed at two levels: at the individual level by these MP, member of parliament, and I am talking about article 105, right? And the second level at which this privileges and immunities is enjoyed by, at the house level, right? So we already have discussed this article 105, where the privileges and immunities are available to member of parliament, that is member of Rajya Sabha and members of Lok Sabha, at the individual level and at the level of house. When I am talking about level, so collectively Rajya Sabha and Lok Sabha as a house also does have certain privileges, right? So that article, in that article we already had clarified that similar level of privileges and immunities that is enjoyed by member of parliament and Lok Sabha and Rajya Sabha as a house, similar immunities and privileges are enjoyed by member of legislative assembly and member of legislative council, that is member of state legislature, and at the house level by legislative assembly and legislative council, right? The only difference is of article. So here at the parliamentary level you had this article 105 that was dealing with privileges and immunity, while at the state level you have this article 194 that deals with privileges and immunities of members of state legislature and house or houses, that is legislative assembly and legislative council. So when content of this privileges and immunity is already almost same, there is no point of duplicating these efforts, right? So whatever privileges and immunity that you have learnt in this parliamentary chapter, similar thing you have to copy paste, except this difference in article 105 at the parliamentary level and article 194 that deals with privileges and immunity of state legislature and these houses, legislative assembly and legislative council. So this topic we are not going to touch. Second topic that we are not going to touch is parts of legislative assembly and legislative independent parts of legislative assembly and independent parts of legislative council will not discuss. Why we are not going to discuss this parts of? Because of similar reasons, because you already know that there are certain part that is enjoyed by legislative Lok Sabha at the central level, and certain part with respect to law is enjoyed by Rajya Sabha, that is upper state at the parliamentary level. So whatever parts, be it in legislative domain, be it in financial domain, be it in administrative domain or oversightory function or parliamentary committee, right? So whatever part that is enjoyed by the Lok Sabha, that is lower house at the central level with respect to laws in action, right? So you have this something called schedule 7, right? So in schedule 7 you have these three kind of lists, that is union list, state list and concurrent list. The only difference, see, whatever part that is enjoyed by the Lok Sabha will be enjoyed by legislative assembly, and whatever parts that is enjoyed by Rajya Sabha generally, means there are exceptions, and that exceptions will point out, but it is traditionally understood that already whatever part that is enjoyed by the Rajya Sabha will be enjoyed by the upper house, that is legislative. Although this legislative council is optional thing, and not every state has opted for legislative council, but whichever 6 state that does have this 6 legislative council, So those legislative council for those 6 states has been put on equal footing of the Rajya Sabha. Again, I am pointing out there are certain exceptional power, or this legislative council that has already been explained in the previous 2 video, that this legislative council is weaker house vis-a-vis legislative assembly and vis-a-vis Rajya Sabha. So that we will point out. But as far as independent parts of the legislative assembly can enact laws on the state list, while the Lok Sabha at the at the parliamentary level can enact laws on the union list, right? So except that difference, whatever power means the legislation or administration or financial power that is enjoyed by the Lok Sabha at the parliamentary level or at the central level, similar power except of the difference of the jurisdiction. So whatever legislation that they will, and again I am not getting into the nitty-gritties, because when we will study this center-state relation, we will see that there are certain nitty-gritties. I am just issuing a general statement. So the general statement would be that whatever power that Lok Sabha, independent power that Lok Sabha does enjoy with respect to the parliament or at the central level, similar powers are enjoyed by the legislative assembly with respect to the state laws, with respect to the state administration, and with respect to the state finances, right? So you can simply copy paste those powers, and similarly with the legislative council with respect to the Rajya Sabha. So that's why we have decided this independent parts of the legislative assembly and legislative council will not discuss. I hope what are the things that we have planned not to discuss would be clear to you now. So what is going to be the scope of this video? So in what areas that this legislative council is weaker as compared to legislative assembly, that is state house itself, and in what areas legislative council is weaker than the Rajya Sabha, because Rajya Sabha is considered as upper house at the central level. So traditionally it is compared that legislative council is equivalent of Rajya Sabha. But when we'll see, you will notice, rather in last 2 videos we already have discussed, when we were discussing the legislative process with respect to the bill, we had compared the parts of legislative council with the parts of legislative assembly number 1 and with respect to Rajya Sabha number 2, and we had opined that how this legislative council's parts are secondary to the legislative assembly and Rajya Sabha, and that's why we had referred that Rajya Sabha at the central level, while it is called second chamber, this legislative council, owing to the constitutionally lesser amount of power that has been given to this legislative council, why it has been called as secondary house. This Rajya Sabha, being upper house, is called second chamber or second house, but this house, legislative council at the state level, is not referred, means generally it should have been referred as second house. When you are calling this Rajya Sabha, legislative council on par with this Rajya Sabha, then you should have imparted it with the equal amount of power or at par with the powers that you have assigned to the legislative assembly, but that is not the case. To avoid this case of joint sitting or constitutional deadlock, what we have done is, what constitutional fathers have done is that legislative council has been granted not equivalent power to this legislative assembly, and that's why we were referring legislative council as a weaker house when compared to legislative assembly and Rajya Sabha. We'll point out in what all area this legislative council is a weaker house. I hope this point you would have understood. Now in the next vertical of this video, we'll discuss rights of minister and advocate general in house or houses. When I am referring to the houses, we are referring to the state legislature which are bicameral. I hope you do understand the difference between unicameral legislature and bicameral legislature. Then we'll discuss languages that are permissible in house and houses. Then what is this quorum, summon, prorogue, although we already know, but we'll discuss that as well. Will hardly take 2 minutes here and there. Privileges and immunity, as we already have described, that we will not discuss. So let us start with the first vertical and let us start discussing that in what all area legislative council is secondary to the legislative assembly and Rajya Sabha, and legislative council is also weaker than the Rajya Sabha at the central level. So let us see one by one those areas. So first area is money bill. So money bill you already know when we were discussing the parliament, so there as well. So money bill draws some similarities at the central level as well. So if you remember, while discussing this money bill, we had said that money bill can be introduced only into the Lok Sabha with prior permission of the president and only by the minister. So similar rule applies here as well. So with respect to the money bill, Legislative Council is on equal footing with the Rajya Sabha as well. But when compared with the Legislative Assembly's power, see, money bill can be introduced as at the parliamentary level. Money bill can be introduced only into the Legislative Assembly by minister and with prior approval of the governor. So here when you compare the power of the Legislative Council with the Rajya Sabha, it is on equal footing. But when you compare Legislative Council's power with respect to the money bill with the Legislative Assembly, then it is a secondary house, because it can't be, money bill can't be introduced into the Legislative Council first. Second difference with respect to our secondary power with respect to the money bill is that when Legislative Assembly passes this money bill and sends it to the Legislative Council, here as well Legislative Council does have limited power. What kind of limited power? So similarly, the power that Rajya Sabha had with respect to the money bill, similar power is enjoyed by the Legislative Council as well with respect to the money bill. So Legislative Council can discuss the money bill, but it can't move the amendment. If it finds that any provision of the money bill or any provision of the budget is not appropriate, the most it can do is that it can suggest some amendment, and it can suggest Legislative Assembly that, hey, Legislative Assembly, I have not been empowered by the Constitution to amend this proposal or to amend this money bill. Certain provision I am finding, we as a house are finding objectionable. Can you amend those provision? Now it will entirely depend on this Legislative Assembly at the state level and Lok Sabha at the central level, whether they do find the suggestions made by the Legislative Council appropriate or not. It is incumbent completely. This Legislative Council can't compel them to accept the suggestions made by them, right? So irrespective of whether this Legislative Assembly take their objections into account or not, even if they does not take their amendments into account, this money bill will deem to be passed. First situation. The second situation is that at most all these things, all this back and forth communication that has to happen, if they have any kind of, see, the first approach would be that Legislative Assembly, whatever money bill that Legislative Assembly has transmitted, Legislative Council says yes, we do approve in the same format. If the second option it opts for, that it asks Legislative Assembly to consider some kind of amendment, that all thing has to happen only in 14 days. If in 14 days, if this Legislative Council keeps sitting, it can't say on 15th day that, hey, I wanted to move the amendment. No, that provision is not available into the Constitution. Within 14 days, if this Legislative Council does not take any action on the money bill, right, that bill, money bill will deem to be passed by the Legislative Council in the format that was sent by the Legislative Assembly. So with respect to the money bill, I hope you would have understood that what is the limitation on the power of the Legislative Council. So that is one difference, that is one area where Legislative Council is not superior, or rather it enjoy inferior powers with respect to the Legislative Assembly in this money bill. The second area where Legislative Council is again what you call weaker house. So suppose a bill has been introduced into the Legislative Council, and after having passed, it will be sent to the Legislative Assembly. Now here Legislative Council's chairman can't classify that what kind of bill it is going to be. It can certify. See, as far as ordinary bill, it can certify that this bill is ordinary bill that we are passing, but it can't certify a particular bill in this category of money bill. presiding officer has this power that they'll classify a bill, that what kind of bill it is going to be, but a bill cannot be classified as money bill by the presiding officer of that particular house where the bill has originated. This power rests only with the legislative assembly. So suppose a bill has been introduced into the legislative assembly once passes the bill, right, it will go to the presiding officer, and presiding officer will have to classify that bill before transmitting into the legislative council. So suppose if the executive has proposed that this bill should be of money bill, this should be categorized as the money bill, but it will be only recommendation by the executive. Executive can't force that, hey, you are supposed to do this, but generally whatever suggestion that executive give, right, after that speaker does consider that advice, and after that, if in the speaker's opinion, if that particular bill does have provision and it can be classified as the money bill, it will classify that speaker will classify that bill as money bill. So the point is that power of classifying a bill as money bill lies only with the legislative assembly's presiding officer, that is speaker, right? This power does not reside with the chairman of the legislative council. So again, legislative council in this area as well does have weaker power. The third vertical, if I talk about, see, council can delay a bill only for maximum period of 4 months. This duration in case of Rajya Sabha was 6 months, right? So what can happen in the first instance? For this, I am not getting into the detail that how this 4-month delay can be caused by this council, right? Because this already, when we were discussing this legislative process in the second video, this point we already have discussed. Just as a briefing, so if you remember, when a bill was being passed by the legislative assembly and it was being sent to the legislative council, in the first instance it could delay that particular bill for the 3 months, and in the second instance, when the same bill, if legislative council does not do anything to the bill that has been transmitted by the legislative assembly continuously for 3 months, legislative assembly in that case will have power to pass that bill again. And in this instance, if the legislative assembly passes the same bill, because the legislative council sat on that particular, the first bill for 3 consistent months, right? So in the second instance, the maximum delay that it can cause is for 1 month. So the maximum delay, if you count this 3 months plus 1 month, the maximum delay for a particular bill that has been passed by the legislative assembly, the maximum delay this legislative council can do is for 4 months. I hope you would have understood. If you have not understood, you can always refer to the second video, because at this point we had discussed in graphic format and we had given around 4 or 5 minutes there, right? So you can understand that. Can be created and abolished on the recommendation of the assembly. So if you remember, when we were discussing this article in the first video, we had discussed that assembly, see how this legislative councils are created, because see, this is, although this is considered as upper house, unlike Rajya Sabha, which is mandatory at the parliamentary level, this legislative council although is upper house, but this is not mandatory. This option of having this legislative council has been made optional, and whichever state, if they want to have this so what is the process of creating this legislative council? So see, the ultimate power belongs to the parliament, but parliament solely cannot initiate this resolution that this particular state needs to have this legislative council. No, it first needs to the resolution first needs to be approved by the state legislative assembly, and only when state legislative assembly passes a resolution with special majority, it will be sent to the parliament, and thereafter parliament will decide whether the state will have this legislative council or not. In this respect, parliament does have, there is no time that has been mentioned in the constitution that after having sent this proposal, after having received this proposal from the state, how much time this parliament can take in approving that resolution. Parliament can approve this resolution only with simple majority. But again, Rajasthan example, if you remember, we had taken, where Rajasthan has passed this resolution of having legislative council in their state from 2012, but the decision on this 2012 resolution for having Rajasthan legislative council has not been taken until this 2020 April, right? So sorry, July, right now we are in, right? So until July, means it's been 8 years since this proposal of Rajasthan has not been considered yet, because of the constitutional loophole that Parliament, it has not been mentioned in the constitution that in what time Parliament should respond to that resolution, right? So this legislative council, so you have this 6 legislative states where you have this legislative council. So assembly at any time, if so, first was about the creation, and if at any times if the legislative assembly of even these 6 states which does have this legislative council, if they decide, the legislative assembly of these 6 states, if they want to decide that okay, tomorrow onwards, or suppose means now onwards, we don't want to have this legislative council in our state, they can similarly pass a resolution to that effect. Their state legislative assembly can pass the resolution with that effect and can send to the Parliament, and Parliament can abolish that legislative. So here again, the very existence of legislative council is incumbent on the will of legislative assembly. So this is a supreme power that legislative assembly has with respect to the legislative council. So I hope these 4 areas where legislative council's power is inferior to legislative assembly, you would have understood. Now the 5th, so you have this 5th point, has no effective say in constitutional amendment bill. So there are various kind of bill. If you remember when we were discussing again the legislative process, so we had cited that you had this ordinary bill, you have this money bill, you have this amending, repealing, consolidating bill, and out of all these categorization you have something called constitutional amendment bill, to which in short format we describe as CAB, constitutional amendment bill. Now broadly it can, this constitutional amendment bill can be categorized into 2 points or 2 classes. The first class would be where the participation of state, see in our constitution it has been mentioned that state cannot initiate the constitutional amendment bills, right? But there are certain kind of constitutional amendment which cannot be passed or which cannot be made effective without participation of the state. In those areas, suppose if you are spoiling, if Parliament want to alter any of the federal structure or any of the matter that has been mentioned in the Schedule 7, right? So any matter that disturbs this federal character of our union, that needs to be ratified by the state as well. So broadly, when I was saying that this constitutional amendment bill can be classified broadly into 2 categories. The first category was that in the first category, if the constitutional amendment bill is being passed, there in those kind of constitutional amendment bill, the participation of the state would not be required, right? It will be simply passed by the Parliament by the special majority, then it will be sent to the President, and if President signs or approves that bill, the constitutional amendment bill will become constitutional amendment act, right? But then there are certain kind of constitutional amendment bill, if they are spoiling this federal structure or if they are altering federal structure of our country, then that bill, after having been passed by the Parliament by special majority, it will be sent to the state legislature, and only when half of the state legislature has passed that constitutional amendment bill, right, then only that can be made effective. Means after a state, it will be again sent to the President, and President signs, and thereafter it will be called constitutional amendment act. Now here this point is that legislative council does not have effect. Let us try to understand it. So suppose a constitutional amendment bill which was seeking to alter federal character of the union, that constitutional amendment bill, when it came to the state for the approval, now you have 22 states which does not have this legislative council, and you have only 6 states which does have this legislative council. Now this 22 states legislative assembly only will pass that constitutional amendment bill, and then it will be sent to the president. But what about this sixth state? If whether that constitutional amendment bill will be sent to the legislative council or not, because as far as this 22 states were concerned, only legislative assembly, they do not have this legislative council, so only legislative assembly passed that constitutional amendment bill and sent it to the president. But what about this sixth because if you are sending to this legislative council, right, this will create a non-piracy in the representation. I hope you would have understood, right, why I am calling this a non-piracy or what you call non-piracy in the representation, because here in these 22 only LA participation, but in these 6 cases, 6 states, you have this legislative council participation. So to what degree this legislative council should have say in passage of this constitutional amendment bill? Because if you are including their participation, then this will not be representative, or this will be discriminatory against this 22 states. I hope you would have understood those points. So this is again a constitutionally vague area, and political understanding, again this is being guided by the political understanding. So the will of the legislative council does not matter a lot in case of those 6 states. Why the will not matter? Similar, only when this legislative assembly in those 6 states, if they have passed, it will be sent to the legislative council, and it is well understood by this legislative council as well that we have to pass. In case if they have objection, their objection is not considered, right? Generally means this is again, as I cited, that this is a constitutionally vague areas, and until now no activist, political activist or lawyer or Supreme Court even has taken a suo motu cognizance in this particular area to have open say that whether legislative council should have a say in these constitutional amendment bill or not. So far the practice has been that this kind of constitutional amendment bill is sent to the legislative council of this 6 states, and legislative councils generally have passed. They have not clashed with the legislative assembly of that particular state that no, you have passed, but from our assessment this should not be passed. If that kind of situation will occur, certainly those kind of cases will go to the Supreme Court, and Supreme Court will have a kind of say that okay, to what degree this legislative council. So as you saw that legislative council generally have concurred with the view of legislative assembly, and that's why again in this area as well we are saying that legislative council in cases of constitutional amendment bill does not have a effective say. I hope this point you would have understood. Then no participation in the president and Rajya Sabha's members election. So this point you already know that when we were discussing the electorates for the presidential election, we had openly said that only the elected member of the legislative assembly from the states will participate. The legislative council again for those 6 states will not participate in the election of what you call this president. And similarly when Rajya Sabha, when state is sending Rajya Sabha members to this Rajya Sabha, that is upper house at the central level, again only legislative assemblies member participate in their election as well. Legislative council does not have say. So it is in these area that you do have legislative council that is weaker, considered weaker as from this legislative assembly or from Rajya Sabha. So I hope these points you would have understood. The next vertical is about rights of minister and advocate general. So at the state level, at the central level you have this Attorney General of India. Similarly at the state level you have this Advocate General. So what are the rights that minister does have in various houses, and what are the rights that these people Advocate General have? So let us discuss this. Although this point has already been discussed again in the Parliament chapter, but there are certain areas that we need to touch, right? So logically speaking, see these minister, any minister. So suppose you have Minister of External Affairs, right? S. Jaishankar, he belongs to the Rajya Sabha. You have this Amit Shah, right? He belongs to the Lok Sabha. Similarly, you have Prime Minister. He also belongs to the Lok Sabha, right? So generally, these people, because he is Minister of the Lok Sabha and he is Minister of Rajya Sabha, if logically you go by, right, these people should be given a right to speak only in the houses that they belong, right? Because other members do not. But just because they happen to be ministers, so suppose tomorrow you have this China incursion going on, and we do have this wide issue of China. So right now, see, he is a member, the Ministry of External Affairs is a member of Rajya Sabha. So if any of the Rajya Sabha member or any political group of Rajya Sabha, if they do have query from the Ministry of External Affairs that how they are cracking, or how they are handling, their ambassadors are handling this issue of China, right? Then how they are interacting with different countries, what kind of messaging that we are doing about China in different countries, how our ambassadors are interacting with the representatives of these countries in their country, then they can ask, they can raise this question from MEA, Ministry of External Affairs. So in Rajya Sabha it is good because he happens to be a member of Rajya Sabha, so Rajya Sabha members can ask question. But what about members of the Lok Sabha? Because he is not member, so in this case ministers has been given right that if Lok Sabha members or the members to which they are not members of, right? So Minister of External Affairs, he is not member of Lok Sabha, but if a political group 2-4 MPs does have question from Minister of External Affairs and Speaker allows, in that case he can come to the Lok Sabha as well and he can respond to the query into the Lok Sabha. But while being in Lok Sabha, if there is any voting going on, if there is any another proceeding, if there is any resolution for reconsideration, then he cannot participate. He can speak on the issues for which he has been called in that particular house, on of which he is not member of. But if there is any voting, then voting rights will not belong to him, right? I hope you would have understood that point. And here on this point we separate ourselves from the Britain. We have opted this parliamentary system from the Britain, but there in Britain, this Ministry of External Affairs, if he is not a member of that particular house, he cannot participate, he cannot even go to that particular house. So what is the mechanism that they do have? So mechanism that the Britain has opted for. So suppose I am taking example of Ministry of External Affairs itself. So he is member of upper house, right? Upper house. Now against this Minister of External Affairs in the lower house, because he is member of upper house, right? So in the lower house he will have a parliamentary secretary, PS I am referring as. So he will have a parliamentary secretary who is member of lower house. So whatever question that has been asked from a member of lower house to this Ministry of External Affairs, Minister of External Affairs, right? So on behalf of Minister of External Affairs, this parliamentary secretary who is member of lower house, he is going to respond the questions of the lower house members, right? So that is one differing point that we do have. That is one practice that we have not opted or copied from the Britain, despite copying this parliamentary system, right? So I hope that difference you would have understood, right? So minister can participate in the proceeding of both the houses, but she can vote only in the house which he or she belongs. What about the second question that we can raise is, so we do have an option that even if a person is not a member of any of the house, if a person is not member of either Rajya Sabha or Lok Sabha, even then he can be made part of Council of Minister and he can remain part of Council of Minister for 6 months. So if he is participating in the Lok Sabha or Rajya Sabha, what kind of rights he or she will have? So in the first instance, when we were taking example of Minister of External Affairs, he could vote only into the Rajya Sabha, but he could speak into both the houses, Rajya Sabha and Lok Sabha. But in case if a person who happens to be a minister, but he is neither part of the Lok Sabha and Rajya Sabha, because of this option, what kind of rights he will enjoy with respect to these houses? So he can't vote until he is a member of this Lok Sabha or Rajya Sabha. He can't vote in any of the house. But again, the first right, that is right to participate in, right to answer the question of both the houses, will belong to him or her. A minister who is not a MLA, which house he will vote in, unless he is chosen as member of any house, he can't vote. However, he will be allowed to participate in the proceedings. So this was about rights of minister. What about rights of advocate general? Why we have put up this separately? Because advocate general is not part of any of these house. Means he is not member, actually not part would be a wrong statement. He is actually not member of legislative assembly or legislative council. Yet there may be, because he is this council, legal council, head of legal council of the state government. So there may be a question any time that members of political groups may would like to ask from this advocate general that what stand you had taken with respect to the our government in that court, what stand you do have against the center, right, in a particular representation. So in those kind of cases, the advocate general can be called in any of the house, that is legislative assembly and legislative council. But again, what you call this advocate general cannot vote, because he is not member of either legislative assembly, but he can speak whatever question that has been asked. Despite not being member of these, he can sit in the house and he can answer those questions. So advocate general can speak in both the houses, but he can vote, he can't vote in any of the houses. I hope this rights of minister and advocate general you would have understood. Similar rights was enjoyed by the minister at the central level and attorney general of India at the parliamentary level, right? So I hope this point, this vertical also you would have understood. Now quorum you already know, because quorum we had discussed in the parliament. Why we have put up this? So I have put up this just to underline this point. So as far as our normal understanding has been so far about the quorum is nothing but a minimum number of people or minimum number of member that needs to be present in a particular house in order for that house to function. So it can't happen, or it can't be the case that where house size, so suppose if I am taking example of Lok Sabha, so Lok Sabha size, so you can't have a situation where although the total size of the house is 545, but on a particular day there are only 10 members sitting and Lok Sabha starts functioning. It can't be the situation, because see, what is the business that Lok Sabha is supposed to perform? So it does have primarily the law making function, right? So if Lok Sabha starts passing a law with 10 members present, so suppose a law has to be passed with the simple majority, so you can't have a situation where 10 members are present and voting, and that law, any particular bill is just passed by the participation or by voting of 6 members. Because if there is any situation that is arising where only 6 members participation is ensuring a law passes, right, so that law will not be considered very representative, but because this law is going to have effect or implication on whole of the country. And just because 6 members of the Lok Sabha or 6 members or 5 members of the Rajya Sabha thought that it is appropriate law, with their limited understanding, it can't be imposed on whole of the country, because apart from the law making, the job of parliamentarian is also to indulge in this discussion and debate on the appropriateness or inappropriateness of the provisions of the law. So there must be some fixed number that, okay, unless these number of members are present in a particular house, no transaction of the business will occur, and that's why you have something called quorum, right? So generally this is the rule, that unless 10% of the members, or 10% of what? 10% of the total size of that particular house. So if I talk about this Maharashtra example, so Maharashtra, if I talk about the upper house, they do have this legislative council, and legislative council size is 78, right? So logically, if we go by the 10% rule, unless you have 8 members, this house should not function. If I talk about their lower house, that is legislative assembly, right? So legislative assembly size is 288, and if we follow this 10% rule, so unless you have this 29 members, legislative assembly can function. So okay, fine, as far as legislative assembly quorum was fine, numbers were there, right? 29 members, so this can be called representative. But what about this legislative council? Only with the participation of 8 members, you are saying that this legislative council is capable of passing any particular bill, right? So that should not happen, right? So there is another rule, either 10% of the total house size, because we do have, if we follow this 10% of the house, see at the central level, that is Lok Sabha and Rajya Sabha, this is 25 I guess, and this is 55, right, or 54 it can, sorry 55 it is, right. So it is fine, right. For the Lok Sabha this is a representative, but at the assembly level this 10% rule can't be applied in all the assembly. As far as UP is concerned, yes, the legislative assembly size is 403, so it will translate into some 41 members, so this is a representative. But in case of assembly which does have just size of 40 or 60, right, so 10% will translate into 4 members, right. So with the 4 members you can't expect that a law will be passed, law should be passed rather, and that law should be imposed on whole of the state, right. So in this case, in the cases of smaller assembly, this rule of 10% can't be applied, and so there is a rule of 10, either 10%, or if the 10% is lesser than 10 number 10, then in that case 10 people should be present. So in cases of a smaller assembly where 10% rule translate into number less than 10, then in that case the quorum would be 10. So you can simply read that either 10% or 10, whichever is larger, right. I hope that point you would have understood, although this point we had discussed, but on this particular point why this number needs to remain 10, either 10% or 10, I had not discussed, and that's why this quorum. So no business in the house shall be transacted unless there is quorum, and this quorum is applicable not only to the legislative assembly, but this quorum is applicable to the legislative council, that is upper house as well. I hope this vertical also you would have understood. What about the summon, prorogue of the house or the dissolution of the house? So see, there are various tools, various similar tool which does derive almost similar. So there is first thing called summon, then you have something called adjournment, then you have something called adjournment sine die, and then you have something called prorogue, right, and then the last thing that you have is dissolution, and this does carry, this is a sequence. So the meaning of summon, I hope I have said it in repeatedly format, right. You had this president lecture, governor lecture, then parliamentary lecture, then state legislature as well. In the first video as well we had described the meaning. So there is summon, to calling a house into the business, adjournment, suspending the business of the house for a limited period, for 2 hours, for 4 hours, 2 days, 3 days, means defining the time that within 2 hours this house is going to convene in next 2 days or 3 days, or this house will remain suspended for 2 days, 3 hours, so for a limited time. Adjournment sine die, adjourning the house, suspending the business of the house for unlimited without defining the time. So that is the meaning of adjournment sine die. Proroguing, after adjourn sine die has been announced by the speaker. See, these two parts, power of announcing the adjournment, power of announcing the adjourn sine die, belong to the presiding officer of that house, that is speaker of the Lok Sabha, speaker of the legislative assembly, and chairman of the Rajya Sabha, and chairman of this legislative council. So these two parts belong to the presiding officer of that house. As far as prorogue is concerned, so once prorogue can be announced only when presiding officer of that particular house has announced this adjournment sine die. So that is one precondition, that prorogue cannot be, a house cannot be prorogued unless adjournment sine die has been announced by the speaker or the chairman, rather presiding officer of that particular house. And this prorogue and summon will be called by governor at the state level and president. This notification, these are actually notification that is published in the Gazette of the state in case of state, and Gazette of India at the president level, or at the central level rather, right. So at the central level you have president, at the state level you have this governor, right. And so once business of that particular house is over, then parliamentary affairs, parliamentary minister at the central level, right, or the leader of the house at the central level, and at the state level similarly, will advise the speaker or the chairman of that house to announce this adjournment sine die, and this prorogue advice is extended to the governor by chief minister and prime minister. Prime minister at the central level to the president, and chief minister to the governor, right? So this is the prorogue. And then dissolution. So dissolution, you already know, if the dissolution is announced, then this whole of the legislative assembly will stand dissolved. So this is, there is slight difference between all these things. So here we are going to study this, what is this summoning and what is this prorogue. So summoning, as I already told you, that it is announced by this summon, and prorogue, notification is issued by the governor, and governor generally announce this summon and prorogue on the advice of chief minister, and chief minister is guided by the advice of council of minister. But I am saying this generally. Again, this is a constitutionally vague area where in the constitution it has not been completely declared that whether governor and the president at the central level, governor at the state level, will always function. As far as this summon and prorogue notification is concerned, he or she always should be guided by the chief minister or not. This has not been clearly mentioned in the constitution, and hence the result has been that at times governors have acted in a discretionary manner, and they have summoned in 2017 you had this Arunachal Pradesh example where governor, without following the advice of council of ministers, had preponed. This house was scheduled, legislative assembly was scheduled to be summoned in January, but he summoned this house legislative assembly in December itself, just to benefit a particular political party. And you can guess that, okay, that political party, or of course, would have been the ruling party from the center. So governors at time, in absence of clear-cut guidelines from the constitution, have acted in the what you call discretionary manner. Although generally most of the time, again I don't have quantifiable data, but 90 to 95% of the time governors had generally abided by the advice of chief minister led by council of ministers. So governor have abided by, but in certain situations there have been deviation. Now the question that you can raise is, see, governor and president as far as concerned, right, they also take oath to protect the constitution, to protect the constitutionalism. They have to ensure that the government of the state continue to function on the constitutional line. So let us take two hypothetical examples just to understand whether governor should exercise in certain situation. Although if we follow what you call the spirit of article 163, so this governor should always go by the advice of council of minister headed by chief minister. So that is the guideline that is mentioned in the article 163. But again, in the same article it has also been mentioned that if governor want to exercise any of the power in a discretionary manner, then he is the only sole authority to decide that whether a particular power should be exercised in discretionary function or not, right? So that is one point. But because he has also taken oath to protect the constitution, to protect the laws of the state, then he should be given some amount of power to protect that constitution. So let us take, see, executive, as far as we are discussing that he should be, governor should be guided by the advice of executive or CM or council of minister, because you have this article 163, right? But there are such, so this executive is most of the time abided, executive itself is abided by something called political consideration, right? So in such situation, when advice of executive is solely guided by the political consideration rather than total public interest, in that situation, from my assessment, president at the central level and governors at the state level should be allowed. But again, only when, as far as governor is concerned, center should release the control on the term, tenure and the appointment. Only then his power, his exercise, independent exercise of power or discretionary power, right, could be considered free from the central control, right? So that is one condition. Let us take a hypothetical, two hypothetical situation to understand that in what all situation this powers of summon and prorogue of the governor can be exercised in a discretionary fashion or independent of council of ministers advice, and that will be considered legitimate, or that should be considered legitimate, right? So suppose the first example is, suppose let us take a hypothetical example. So you have this Madhya Pradesh, and you have seen this political defection. So earlier you had, after assembly election, you had this INC led government, Indian National Congress led government. Thereafter certain defections happen, and after that this BJP government right now you have in power. Now suppose this session is ongoing right now, and this session was scheduled for, suppose, assembly session I am talking about. So suppose this session was scheduled for 20 days. Now this BJP is in power. Suppose 10 of MLA of BJP, out of any political reason or out of any reason, 10 of MLA of this BJP decides to either resign or they defect to the INC. And because of this 10 defection or 10 resignation, this BJP government gets into minority. As soon this BJP government get into minority, suppose this INC starts thinking of that, we'll 2 days down the line, we will move this something called no confidence motion. No confidence motion. Now anticipating this move, that we are lacking in numbers, we do not have these 10 MLA, anticipating that we will not be able to successfully get through this no confidence motion, sensing that BJP suggests Speaker of the House to adjourn sine die the House first, right, and thereafter advises Governor that, hey Governor, can you prorogue this Legislative Assembly, because this no confidence motion can be moved only when your Legislative Assembly is in session, right? So just about when they were planning, this INC, Indian National Congress, was planning to move this no confidence motion within 1 day or 2 days, right? Chief Minister, because he does have power and Governor will be guided by his advice in proroguing the House, CM advises, although it was scheduled to continue for 20 days, right? So in this situation, should Governor be abiding by the advice of Chief Minister or not, or should he be because he already know the political situation, Governor, that 2 days down the line no confidence motion is being mulled by this INC, right? So whether Governor in such kind of imaginary situation or rather this kind of situation has occurred in the past as well, where governors hastily, sensing that particular political party is in minority, has moved hastily on the advice of ruling party and has prorogued the House just to protect the interest of the ruling party at the center. So this has happened. There are numerous examples too. So that was the first situation where, from my understanding, in these kind of, because Governor and President has taken this oath of protecting the Constitution, and a running minority government should not be allowed. Now the second situation can be that, suppose this political defection does not happen at the time when session is ongoing. There is no session that is ongoing and political defection. Now this government again has gone into the minority because of this 10 resignation or 10 defection. Now the House is not in session. Should the Governor, and now suppose the government of was INC, at the central level you had this BJP government. Now does Governor or should Governor be given right to summon the House at his own without if the session was to happen in, suppose, November, scheduled session was in November, but just because this INC government has gone into the minority and it is benefiting a particular political party, should in this situation Governor be given the House, summon the House untimely? So that was the second situation, right? So that is very subjective thing, and these kind of questions, I guarantee you that these kind of questions are not going to be asked into the prelim, because these are traps and Constitution has not been amended to answer these kind of questions, or despite having cumbersome situation, Constitution has not been amended, right? Even Supreme Court's decision, right, has not been clear on these kind of points, right? So rest assured, these kind of trapping, the only thing that you should know that it is the power of governor to summon and prorogue the house, and he does so on the advice of chief minister, right? Whether that advice is binding on the governor, whether governor can independently exercise this summoning power or prorogue power, right? Those nature of question, I guarantee you, will not be asked into the prelim. This is a subjective or analysis based question, and these kind of question can be asked in mains to check your analytical ability, right? So from that angle I discussed this. The governor may this was about summon. Governor may from time to time prorogue the house or either house, or it can dissolve the legislative assembly as well. I hope these points you would have understood, right? So governor's power to summon and prorogue is discretionary, question mark. Governor have mostly summoned and prorogue the house on the advice of council of minister led by chief minister. However, there have been deviation in certain cases. So I hope these points you would have clarity on. Now we are moving to discuss, rather you have to attempt these MCQ. So this is the first MCQ, second MCQ, third MCQ, and fourth MCQ. So these are the 4 MCQ that I expect you to attempt. So next chapter would be on High Court. So unless we come up on this High Court, till then, bye bye.